This Grammy-winning composer is suing a comedian for $27 million over a joke about the Lion King lyrics for the song The Circle of Life.
It's the Lion King.
Well, do it.
Sing it again.
Okay.
Oh, no. Baba City, Baba. City Gonya.
Are you looking for something?
I don't know. That's just.
Let me tell you something.
Okay. What did I say? What did I say?
You said nothing.
Is that Zimbabwe?
That's Zulu. That's
Zulu.
South African.
Can you do that?
Yeah, I can do it.
Do it.
So
Ready?
you sing it like Nansi Ngonya Bagiti Baba.
You were way off.
Ingonyama.
All right. All right.
Hold on, can you do that one more time?
Do that again.
What does it mean?
It means, look, there's a lion. Oh my God.
You're joking. That is not what that means. That is not what that means.
That's exactly what it means.
That's what it
It means, look, there's a lion.
Oh
Oh my God.
It's a
Look,
lion.
there's a lion. Oh my God.
It's a lion.
This whole time, I thought it was like this beautiful, majestic.
Look here, there's a bull lion.
It's a lion!
Can you believe that? No, we can't. They gonna fall for this bush.
That clip and some back and forth about the clip between the two men went mega viral. And when the comedian refused to back down about his comments, the composer of the iconic opening chant filed a lawsuit in federal court in Los Angeles.
I am officially getting sued for telling a joke. Look, there's a lion. Oh my God.
You're joking.
And that's why I'm getting sued for $27 million. And to make matters worse, I got served the lawsuit while I was performing on stage. What is this? What is this? Service. Oh, shit, I just got served. Oh, shit.
But the problem for the composer is this. In my opinion, the case is complete crap. Not a single cause of action here is sound. And it has a very high likelihood of backfiring hard and in the most expensive way. Not only is there a high likelihood that this case gets dismissed on a basic motion to dismiss, but this case was filed in California, where the anti-SLAPP laws are incredibly friendly to defendants, which means Lebo M, the composer of these lyrics, could end up seeing not just all of his claims dismissed early, he could end up paying all of comedian Learnmore Jonasi's costs and attorney's fees. Honestly, this is such an easy anti-SLAPP case that you would think that the whole lawsuit was just an elaborate early April Fool's joke. Let's get into it. This is Lebo Moraki. Most people know him as Lebo M. He's a Grammy Award-winning South African composer and performer, born in 1964 in Soweto. I hope I'm pronouncing that correctly, actually, during the height of apartheid. He rose from exile in the US to a essentially legendary status. And in 1994, he composed and performed the opening chant of Disney's The Lion King. You know the one I'm talking about. Now, if you're not aware, The Lion King is one of the biggest cultural landmarks in film history. It was added to the Library of Congress's National Film Registry at one point. It also won Academy Awards, and Lebo M's chant is arguably the most recognizable moment in the entire film. No one knows how to pronounce it or how to sing it, and yet everyone somehow kinda sorta knows it. This chant and the song that brought it infamy was reprised for the 2019 live-action remake. And most recently, Lebo M returned to work with Disney again on Mufasa. Now, according to Lebo M's complaint, the chant is written in isiZulu and isiXhosa. He also alleges that the 2019 soundtrack shows that the official contextual translation is "All hail the king, we all bow in the presence of the king." So that's the plaintiff. Now let's talk about the defendant. But first, I do have to thank this video sponsor for making videos like this one possible. This video is sponsored by Masterclass. Masterclass is one of the premier edutainment providers out there. They offer online seminars taught by over 200 industry experts in a wide range of fields. Plans start at $10 a month billed annually. From entrepreneurship to writing to raising kids to all kinds of cooking, there really is something there for everyone here. Recently, I took Martha Stewart's class that has the tagline, "Think like a boss, live like a legend." And while that definitely is a good descriptor for the class, for me, the biggest takeaways were all about maintaining your productivity and growth, doing what you love, and always looking ahead to the future to continue evolving as a person and professional. Now, I have always loved Martha Stewart ever since I was in elementary school, when she was my morning comfort food on days that I was homesick from school. And so it was really great to watch her class and see all the ways that her business has evolved since then, to look at her as an example of how a person can achieve lifelong success by continuing to look for ways to adapt and grow. And it was really inspiring to think of how I might be able to continue doing the things that I love and also to turn those into successful business ventures. And now you can get inspired by classes like this too with an annual masterclass subscription, which right now you can get for at least 15% off. Just click on the link in the description below or scan the QR code on screen and they'll know that I sent you. Learn from the best to become your best with Masterclass. And thanks again to Masterclass for sponsoring this video. Okay, so let's get back to the video and talk about who the defendant is here in this case. This is Learnmore Jonasi. He's a Zimbabwean-born comedian and content creator. He has a massive following on Instagram where he shares clips from his stand-up routines as well as some more original material for social media. He won the 2019 Pan-African Comic of the Year Award as well as the National Arts Merit Awards for Outstanding Comedian. And since then, he's won comedy festivals in Boston and Jersey City, and he also was a finalist on America's Got Talent in 2024. And in recent years, he's been touring the United States doing stand-up. Now, like any good comedian, Jonasi's not just making people laugh, he's also making some social commentary. And he has a whole bit in his stand-up routine about how American movies portray Africa. Check this out.
Whenever America makes a movie about Africa, they don't even try. You know, like The Lion King. I watched this movie, I was like, why do these lions have American accents? Yeah, first I was like, water. I was like, water? That's not how you say it. It's water.
So clearly he's coming from the perspective of being someone who's from Africa, and he's commenting on a movie about Africa, but made by, well, all American Hollywood. And you can see where he's going with this. It's commentary on representations of Africa and Africans in Hollywood. So now, keeping this in mind, let's go back to this podcast episode that went super viral. At one point, Learnmore talks about why he has such a gripe with The Lion King.
Oh, wow.
So my problem with The Lion King is this.
Yeah.
Oh, you know, you watch the movie, you're like, and in Tarzan too, it's like, you watch the movie, the lions had American accents in Africa. Right?
Oh, in Africa.
James Earl
that's right.
Jones.
Yeah,
Yes.
that's right.
And then you had the monkey with the accent.
Yo,
That's heavy.
Rafiki knows the way.
Yeah, you're like, why is the monkey with the accent?
That's hilarious. That's a good observation.
Wow,
Yeah,
wow.
yeah.
I've never thought
Why
about
is
that.
the
The question is, who are you?
I thought I knew.
You know, this is what happened. You know, I was watching The Lion King, and my question was, why do these lions have American accents? Aren't they like in Africa? And the only accent they gave it to the monkey. What the fuck? And it was Caribbean. What the fuck, man?
He also talks about his issues with other Disney movies like Tarzan.
Tarzan is a white guy that went to Africa, right?
Yeah.
And then now the monkeys are like, I'm gonna teach you our language. So he speaks to the monkeys. What about the people that live there? So you mean all these black people that live in that, they don't know how to speak? Why the white guy?
It's facts. Facts. I never liked Tarzan. Get that out of here. White dude from nowhere with long hair.
Yeah, well, long hair is
And
like
running,
talking to the
running
monkeys.
Africa. I mean, enough of this bullshit.
Wow.
Don't-
And he also talked about the 1988 classic Coming to America.
To change your life.
Okay.
You know Zamunda?
Zamunda, yeah,
We have a
Zamunda.
place called Zamunda.
Yeah, Zamunda, coming to America.
Yeah.
Zamunda is a real.
Good morning, Your Majesty. It is another beautiful day in Zamunda. And, Simi, what is it now?
A real place?
Zemunda, yes.
We thought that it was a made-up place.
No, it's a real place.
My son
Where?
Yeah,
works.
Kwazimunda.
Huh?
It's called Kwazimunda.
Kwazimunda.
A kwa, which means it's like a, you know, what you call it, like that you know, that place or something like that. So
Wait,
it's
Kwazimunda.
Wait, hold on. Put breaking news right across the screen.
Zamunda
Right
is
here.
real.
Zamunda
We
is
thought
real.
it was bull.
How many comedians have joked on it? Oh,
Judge,
how come we
Zamunda
can't
ain't
have,
real.
how come they can't
It's
make a movie about a real place? It's a fictitious
It's
place.
not-
No, it's real. There's a
In
place-
Zimbabwe.
You go to Google.
You can't look it up.
Can we Google?
Anyway, so in this podcast interview, Learnmore obviously also talked about what he said was the actual translation of the Zulu chant at the very beginning of the Lion King's opening song, The Circle of Life.
Well, do it.
Sing it
Do
again.
it.
Let's hear it.
Oh, no.
Wasikanya Baba City Baba City Gonya.
Are you looking for something?
I don't know. That's just.
Let me tell you something.
Okay.
He thought he
What
could
did
be
I
African
say?
by
What
looking-
did I say?
You said nothing.
Is that Zimbabwe?
That's Zulu. That's
Zulu.
South African.
Can you do that?
Yeah, I can do it.
Do it.
So
Ready?
you sing it like Nansi Ngonya Bagiti Baba.
You were way off.
Look, there's a lion. Oh my God.
You're joking. That is not what that means. That is not what that means.
That's exactly what it means.
That's what
It means look, there's a lion.
Oh my God. It's a
Look,
lion.
there's a lion. Oh my God.
It's a lion.
This whole time, I thought it was like this beautiful, majestic.
Look here,
Like,
there's a bull lion.
So this clip went absolutely viral and took off across platforms and across the internet. Many people thought it was hilarious. Others, though, were apparently furious, saying Jonasi disrespected African culture. In fact, Jonasi said in a post on Instagram that he started getting threats in his inbox.
Well, it was never my intention to disrespect anybody, especially from home, especially African culture. So when I went on that podcast, my intentions was actually to talk about African identity. If you have time to go on the podcast, you can actually see the stuff that we covered. And I hate that 1 minute comedy moment took away from the conversations we had on the podcast, man, which sucks. So with that being said, I'd like to apologize to anybody that I hurt. It was never my intentions, but comedy has a way to crack open a window for a conversation. Now we can talk about it, you know. I had no idea the chant from the Lion King, Nansi Inkonyama Bagiti Baba, was a royal, you know, calling, like a royal welcoming song for the king when he arrives into the room. What I thought was it was a song from the Lion King.
Meanwhile, Lebo M himself says he reached out to Jonasi through Instagram DMs, identifying himself as the composer and provided what he says is the correct translation. I will say, before I go on into the alleged details of this text conversation or DM conversation, I do find it weird that Lebo M doesn't include any screenshots or any exact reproductions of what's said in this exact conversation. Instead, he gives like partial quotations of some of the things that were said and a lot of summary, particularly summary of what he himself said in this interview. And honestly, that makes me a little bit skeptical about his portrayal of like the overall nature of this conversation. Personally, I want to see screenshots. I want to see exactly what was said. I want to see the timestamps. I want to see all of those details so that I can examine it myself. But aside from that, let's go over a little bit of what Lebo M alleges they said to one another in this exchange. The complaint alleges that Jonasi responded to Lebo M that jokes are meant to open the window to start a conversation. Lebo M then says he pushed back. The complaint says he told Jonasi these comments sought to erase over 30 years of work. And here's where Lebo M thinks is the key part. According to the complaint, Jonasi responded, "Unfortunately, I'm not going to stop talking about everything and everyone, including myself." And so then Lebo M filed the lawsuit. So let's break down some of the specifics of this lawsuit. The complaint was filed on March 16, 2026 in the U.S. District Court for the Central District of California. It seeks more than $20 million in actual damages, plus punitive damages on top of that. Then he's also seeking $7 million in disgorgement of Learnmore's profits from the joke, which Lebo M, I don't know how he does this, but he estimates it to be about $7 million. Anyway, in the complaint, Lebo M alleges 4 main causes of action. So let's walk through each one and talk about why, in my opinion, each one of these is basically complete BS. First up is Lebo M's claim under the Lanham Act. That's federal trademark law. The complaint alleges Jonasi's false characterization creates a misleading description of Lebo M's work, diminishing its value. Okay, so right out of the gate, here's one big thing about trademarks. Trademarks protect a word, phrase, or design that identifies your goods or services. Think of it like the name on a soda can. When you see Coca-Cola, you know exactly who made it because of the logo, the name, and even the designs on the can, or even just the shape of the bottle of Coca-Cola. It's all intended to give the consumer a shorthand way to identify the products they're choosing between so that they don't have to spend any time or resources investigating the source of their product. That's what trademarks do. But the thing is, trademarks don't protect every single kind of intellectual property out there. In fact, when a plaintiff asserts some kind of IP right, they have to place it into the correct category between trademarks, patents, and copyrights because these 3 categories offer different kinds of protections. So placing it in the wrong category will surely get your claim dismissed by the court. And we can just look at the USPTO's own website super quick, which says song lyrics are protected by copyright, not trademarks. And even if whole song lyrics could be trademarked, Lebo M doesn't even allege in the complaint that he owns a trademark in these lyrics. He makes no allegation of trademark registration with USPTO, no allegation that he's using this as a mark in commerce. And you know, all of that might be because, well, if anyone owns a trademark to these lyrics, it would surely be the House of Mouse. Disney is notorious for keeping tight ownership over the IP of their films, TV shows, and other content, and I would honestly be floored to learn that they allowed something as iconic as the intro chant to The Lion King to be owned by someone else. And that includes someone else who had a very big hand in creating that art. So already, just right off the bat, we've identified a number of serious issues in this complaint with this first claim that can get this first cause of action potentially dismissed. So let's look at the second cause of action, defamation per se. The complaint alleges that Jonasi made a false statement of fact when he said that the chant means, "Look, there's a lion, oh my God." And he alleges that this damaged Lebo M's professional reputation. Now, we've talked about defamation a ton on this channel, but if you're not familiar, for defamation, you have to show a number of things. First, in order to win, the plaintiff has to show that the defendant made a false statement of fact. Second, the plaintiff has to show that this false statement of fact was actually about the plaintiff. Third, the statement has to have been published to third parties. And finally, when we're talking about defamation per se specifically, the statement has to be about the plaintiff in some way that basically subjects him or her to intense reputational harm. I'm talking about things like where the defendant made a statement claiming that the plaintiff committed a crime or that they have some kind of a terrible disease like an STD, or that they did something that is a complete no-go in their entire professional field. If the alleged statement doesn't fit into a category like that, then we're talking about basic defamation. And on top of that, because Lebo M is a public figure here, he also needs to show actual malice. That means he has to show that Jonasi either knew that what he was saying was false or was reckless as to the truth or falsity of the statement. In other words, he knew that there was a really good chance that what he was saying was false, but he went ahead and said it anyway. So on the other hand, if there's any reasonable basis for the defendant believing his statement was accurate at the time that the statement was made, then actual malice won't be able to be proved. And remember that text or DM conversation that Lebo M alleged about earlier? So he seems to think that because he told Learnmore Jonasi in this exchange that Jonasi got the meaning of the chant lyrics wrong, that this means Jonasi had actual malice. Aside from the fact that this could fit into a wider, more nuanced discussion about the difference between translation and interpretation, there's also another big problem here for Lebo M. I mean, for one thing, the complaint itself acknowledges that Ingonyama, I hope I'm pronouncing that correctly, can literally translate to lion in Zulu. And this same literal translation has been published multiple times to the public before. For example, here's a 2019 article on Classic FM's website showing the same exact translation Jonasi was talking about. And listen to this interview with Billy Eichner and Seth Rogen, where they sat down for an interview to promote Disney's own 2019 live-action remake of The Lion King, where they played Timon and Pumbaa.
Do you know what the opening lines are in English to The Circle of Life?
You know, I do not.
You don't know?
I don't know.
Savannah, like, what are they saying?
What does that
Yeah,
mean?
do you know what they mean in English?
No.
So this is like a rite of passage you have to go through as an usher. You learn these words.
Wow.
So the beginning words mean, here comes a lion, father. Oh yes, it's a lion. Here comes a lion. Oh yes, it's a lion. We're going to conquer a lion.
We're gonna conquer a lion.
Yeah.
Wow. I'm glad they went the way that they did.
Yeah. It sounds better in the language that it is sung in.
I think much more poetic.
Here comes a lion.
That would
it's a
sound
lion.
Really dumb, actually.
Did we mention it's a lion?
They go like super literal. Yeah. Who knew?
You can get away with anything in a foreign language.
Exactly.
What do you know? That's exactly the same translation that Jonasi used. And Disney didn't hold back that interview. I mean, ostensibly, they didn't have a problem with it. Even the BBC, in its article describing an interview that they had with Lebo M about his work, described the chant as meaning, "Here comes a lion, father." So how exactly is Lebo M going to prove actual malice? Remember, if there's any reasonable basis for Jonasi believing his translation was accurate at the time that he made those statements, the plaintiff cannot meet that burden. And the way I see it, the reasonable basis is everywhere. And that's ignoring the fact that the complaint alleges that the false statement was about the chant, not about Lebo M personally. That's a real problem for defamation, let alone defamation per se, because remember, one of the elements is that the statement has to be about the plaintiff. Okay, so then there's the third cause of action, trade libel. For trade libel, you have to show essentially that the defendant made an untrue statement that disparages the quality of the plaintiff's product or service, and that this harmed the plaintiff financially because some third party, like a consumer, reasonably relied on that false statement. And here, Lebo M's biggest problems are this element that someone relied on the defendant's statement, and this other element that this reliance caused the plaintiff direct financial harm. On this point, Lebo M says it's causing him financial loss because he's touring in Europe and people keep asking him about the translation. Okay, and people asking questions is not reliance causing financial loss. Like, how is that costing him anything? And the biggest allegation of financial harm in this entire lawsuit, Lebo M says he has legitimate concerns whether Disney will call on his services again, despite the fact that they've been working together for over 30 years, to include specifically the last 2 years for a new project. So he alleges that he has concerns. Not that Disney actually dropped him, not that Disney has even communicated that they're unhappy with him because of this viral clip. He's just, for some reason, worried that they might. I mean, remember this interview?
Here comes a lion. It's a lion. Really? We mentioned it's a lion.
They go like super literal.
Again, this was back in 2019 when Billy Eichner and Seth Rogen were promoting a Disney film. And Disney still hired Lebo M for Mufasa after that. So I'm claiming BS on this claim as well. Anyway, his final claim is tortious interference with prospective economic advantage, which we can just shorten in this video to just tortious interference. This one, again, is about Lebo M's business relationship with Disney. For this one, Lebo M has to show that Jonasi knew that Lebo M had a prospective business relationship with Disney, and that Jonasi intentionally did something to essentially break up that relationship. But here's Lebo M's biggest problem with this claim. He has to show that Jonasi engaged in independently wrongful conduct. That doesn't mean Jonasi did something like mean. It means that his conduct has to be otherwise unlawful, something like fraud or breaking into someone's computer to like hack into their database. And on top of that, for this claim, Lebo M also needs to show that his Disney relationship was actually disrupted. But the complaint says that he's been actively working with Disney on Mufasa for the last 2 years. Like I said before, there's no allegation that Disney said anything about wanting to end the relationship. So where are these damages? Okay, but here is the really big kicker, because this is the part that he really should have thought about before filing this awful lawsuit. So remember that this case was filed in federal court in California, and California has one of the strongest anti-SLAPP laws in the country. To back it up just a little bit at the start, when we're talking about anti-SLAPP, we're talking about SLAPP lawsuits, and SLAPP stands for Strategic Litigation Against Public Participation. These are lawsuits that we all understand are actually designed to silence people for exercising their free speech. California's legislature, like many states, decided that they didn't want that happening, so they passed a law basically to stop it. And even though this case is in federal court, the Ninth Circuit has confirmed that California's anti-SLAPP law applies in federal cases in that circuit. Here's how it works. The defendant files what's called a special motion to strike, often also referred to as an anti-SLAPP motion, and the court applies a two-step test. Step 1 is the defense's burden. The defense has to show that the challenged cause of action arises from an act where the defense is acting in furtherance of their right of petition or their right of free speech in connection with a public issue. So there are a couple phrases in there that we need to define. First, there's an act in furtherance. An act in furtherance is generally defined to include statements made in or connected to official proceedings or statements made in a public forum in connection with an issue of public interest. Second, we have to see whether the challenged cause of action arises from protected activity. The California Supreme Court has said that what's most important there is whether the cause of action is based on the defendant's protected free speech or petitioning activity. In other words, it can't just be the case that the lawsuit was filed after the defendant engaged in some protected activity. But here you could also just ask one basic question. Was this action brought to chill the defendant's First Amendment rights? If the answer is yes, then the defendant clearly meets the burden of step 1. So taking a step back, this really doesn't take all that much to show. You don't really need to prove anything. So long as the defense can show that the heart of this whole issue is the defendant using his or her First Amendment rights, they meet this burden. If the defense does that, the burden shifts to the plaintiff, where the plaintiff needs to show a probability of prevailing on the claim. So what does this require? It doesn't necessarily mean that the plaintiff has to prove the entire claim at the outset, but they do have to show that they have enough basis to their claim that they can win. This might not sound like a lot, but let's take a step back for a moment to explain what normally is happening at this stage of litigation. So usually at this early stage of a lawsuit, the only thing a plaintiff has to show is that their claims are plausible. That is a very low bar. And that's for a good reason. American courts want a very low threshold for entry into a lawsuit. It's because usually plaintiffs aren't expected to have all the information they need going into the lawsuit in order to prove their case. In fact, usually the defense holds important evidence that they really don't want to give up. And that evidence outside of the context of a lawsuit is very often something that they're not actually required to give anyone because it might be private information, for example. So that's why we really want to have a low burden of entry at the beginning. We want to give the plaintiff a chance to get discovery, and so that both sides can get access to all the evidence that they need from the other side, and then determine if it's a case that should survive further. So that's a typical lawsuit. But when the defense files an anti-SLAPP motion, the bar for the plaintiff goes way up. You see, now the plaintiff has to show that they have a probability of prevailing on the claim, and that's before any of this discovery has taken place. And here's why that matters for this case. We just went over a bunch of reasons why Lebo M's claims are all crap. The trademark claim should fail because lyrics aren't trademarkable IP. And even if they were, he most certainly doesn't actually own any rights to any trademarks to the lyrics. If anyone does, it's likely Disney. After that, defamation per se fails because the literal translation of the words has a reasonable basis. And the statements at issue weren't even about Lebo M personally. They were about the lyrics. Trade libel should fail because there's no allegation that anyone anywhere relied on Jonasi's statements. And there's also the part about there being zero allegation of actual financial loss. And tortious interference should fail because there's no independently wrongful conduct. And again, no disruption of Lebo M's relationship with Disney. So I really don't see how the plaintiff here can show that there is any reasonable probability that he will prevail on literally any of these claims. And here's the part where this whole lawsuit completely backfires against him. Under California's anti-SLAPP statute, if the defendant wins the special motion to strike, the plaintiff is required to pay defendants reasonable attorney's fees and costs. So yeah, think about that for a minute. You file a $27+ million lawsuit against someone, and if the court finds that you were trying to shut down their free speech, you end up writing the check for their lawyers. This is the ultimate Uno reverse card in litigation.
See, as you can see, the more you around, the more you're going to find out.
So the way I see it, you got a Grammy-winning composer suing a comedian for $27 million over a literal translation of Zulu lyrics that multiple outlets have also published over the years to include a Disney-approved interview. And in my opinion, not only is this entire lawsuit just ridiculous at the outset, it has anti-SLAPP written all over it. If the defense files that motion, I think they win, and Lebo M ends up footing the bill for Jonasi's lawyers. But those are my thoughts. What do you think? Do you think this case has any legs to stand? Or do you think that it is likely that this is going to backfire? Do you think it's a big deal that there is this difference of translation or interpretation between the two sides over these lyrics? Let us know your thoughts in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you would hit the like button. It does help us with YouTube algorithm gods. And if you need help for a real legal issue in your life, contact us at the Bytes Law Group. Our website is linked in the description below.
Now, something that can make a big difference in these cases is whether or not your case is in the hands of a good lawyer. And so many people are out there fighting these battles without the best person on their team. I started Legalbytes because I saw this massive gap between how the legal system actually works and what most people understand about it. When you don't know your rights and you can't understand legal jargon that's used, when you're intimidated by the whole process, that's when you're most vulnerable. Making these videos, breaking down trials, explaining the law in ways that actually make sense to most people, that has been incredible. But after years of doing this, I wanted to do more. Because the thing is, when you're facing a real legal problem, you need someone in your corner who gets it. And that's why I created the Bytes Law Group. It's the same mission as this channel. Make the law work for you, not against you. Whether you're dealing with a consumer issue, you've been wronged by a company, or you just need someone to fight for your rights, we are here to help. I built this firm on the same principle as I built this channel. You deserve to understand what's happening in your case. You deserve straight answers, and you deserve a lawyer who treats you like a person, not a case number. We are taking the same approach that I take in every single video, breaking things down, empowering you with knowledge, and actually giving a damn about the outcome. So if you need legal help, check out Bytes Law Group at bytes.law, also linked in the description below. And if you don't need us right now, that's great too. I hope you keep watching, keep learning, and keep growing your understanding of your rights. That's how we make the world a better place.